So how do I protect my invention internationally? Hi, everybody. I'm JD Houvener, owner, founder, and patent attorney at Bold Patents Law Firm. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. That book and more is available right below at the Bold Inventors Kit. Download that today and get your copy and read through it to understand the patent laws as they are today. What's important about international inventing, international patenting, is this concept of the World Intellectual Property Organization. They and a lot of patent attorneys around the world have come together to join forces and to have what's called a treaty regarding patents. This is the Patent Cooperation Treaty. And for most patents, utility patents that is, there's a great way to have reciprocity, if you will. They will be able to rely on each other in the examination so long as they follow the rules under the World Intellectual Property Organization Treaty. The way this works, in a relative nutshell, we only have a few minutes here to answer the question, is you pick one country and they are designated as the International Search Authority. And so that examiner, and if you're from the US, you'll likely make the US the ISO, they will be able to do the search on behalf of the whole world so that there's no duplication of research. That search is so vital to what your international rights will be that you want to make sure that that basis, what's submitted to that initial application, has as much as possible, every single bit about your invention. That outcome will lead to perhaps a number of international filings. Now, there is no such thing as a single international application. What it is, it's a placeholder, right? So that PCT filing and the international search that's performed, that will be the basis for any country you then choose to file into. But you do have to take that step of actually manually filing what's called the national phase filing in any country that you want to seek rights in. So, right, there's over 180 countries in the world. You may want to pick maybe only a handful that you think the market is ripe for your invention. And you think maybe that will be the best place for you to commercialize or to license or to sell directly to customers what your product, service, or invention entails. So after conducting research, you want to carefully select which countries you want to file into, work with a U.S. attorney at Bold Patents perhaps, and have us get a hold of another attorney or law firm in the foreign jurisdiction. They will then take your U.S.-based filing, translate it if needed, and submit it to their own country's patent office, following the rules that their country has. The big catch, of course, is that that examiner in the foreign country will have to use the international search report that ISA created, right? That original search that will benefit any country that's a member of the treaty. Now, most every single country you've heard of is a part of the treaty. There are a few outliers, and please get with us to talk about them. But if you want to proceed with Australia, the European Union, any country in there, Canada, Korea, Japan, Indonesia, a lot of countries that are making a lot of headway in terms of their economic growth, you will be able to use the international treaty platform. So once you submit that application with a member country using foreign counsel, that examination is still going to happen. But again, they have to use the same search and basis for what's called novelty or non-obviousness in order to make their decision about whether to grant a patent. The other big beauty and benefit here is you can leverage earlier searching and examination. If you're smart, you have the US examination because that's likely where you started if you're watching this video. And the US examiner may go back and forth with you, either on the merits of novelty or non-obviousness, or looking at prior art, perhaps even Section 101 on abstract idea. Once you navigate through the US patent system and can achieve that amazing moment, getting a notice of allowance, meaning the US examiner says, okay, these claims as written are good to go. Now you can file it foreign in many different countries, and they will almost certainly follow the same examination that the US examiner found. But once you gain some confidence in the US, that makes sense then to invest further into other countries overseas. So that's how you do international protection. It's one country at a time. But the great part about the PCT is it buys you more time, gives you the benefit of having one search done on behalf of the whole world. It gets you taking that step so you can make logical, risk-based decisions on how to proceed, how much investment to make. Hi, everybody. Hope you have a wonderful day today. Go big, go bold.